everyone. I'm Todd Frahm. I'm a partner with Tyler Law, LLP, and I work with families, fiduciaries, agents on probate and estate-related real estate sales throughout California. Today's goal is to give you a practical, agent-friendly roadmap for buying and selling real property from a probate estate, not a trust, so you can spot issues early on, set expectations, and avoid preventable delays. So before we get started, just a quick disclaimer, as always, this is general educational information, not legal advice. It's not tax advice, but it's not a substitute for advice from a probate attorney handling a specific case, escrow, title, or CPA. Probates are very fact-specific area of law, and the procedures vary a bit, county by county and judge by judge. So if you hear me say it depends, that's because the probate rules interact with title history, family structure, debts, and court calendars. So here's the plan for the next 15 minutes. First, kind of a probate 101, what probate is and why it happens. Second, when probate is required versus common exceptions you'll see in real estate. And third, who has the authority to sell and when they actually have that authority, letters, and the difference between IAEA authority and full authority. Fourth, then, what title and escrow typically require in a probate sale. Fifth is going to be timing and deal structure realities, notice, creditor periods, publication, and court calendars. And then sixth is going to be listing and contract mechanics, signature blocks, disclosures, including limited knowledge issues. And then seventh would be the pitfalls and red flags. That should cover what we're going to be doing here today. So what is probate? Probate's a court-supervised process to transfer a person's assets after death to pay its valid debts and ultimately distributes what's left to the heirs or the beneficiaries. So for real estate agents, here's the key concept. Probate is not about whether there's a will. Probate is about whether the decedent, person that passed away, owned assets that require court administration to transfer. So why does a probate happen? Well, one, the person died owning real property in their individual name, meaning there was no trust, there's no survivorship feature, and there is no other transfer mechanism. Two, there's a will, but a will typically does not avoid probate. A will usually just tells the probate court who should receive the assets. Three, there may be disputes, debts, missing heirs, or title issues that make court involvement necessary. And in probate in California, it usually means a formal petition has been filed in the Superior Court, a personal representative is appointed, required notices, and in many cases, a supervised sale process, unless the representative has certain authority. Who's had a listing where the family has said, we have a will, so we don't need to do probate? Well, that misconception right there is one of the biggest causes of early deal confusion. So now let's talk about when probate is required and when it's often avoided. So the situations that are commonly going to require a probate is going to be like if the decedent owned California real property in their individual name and there's no surviving joint tenant, it's not in a trust, and no other transfer method applies. Probate is likely going to be required to sell or to refinance that property. So the common exceptions that you might see, again, kind of a practical list here, is going to be if it's in a living trust. If the property was titled in the name of a trustee of a living trust, the successor trustee may be able to sell without probate. Today's talk is about estates, probate estates, not trusts, but you should always check the vesting. If title is joint tenancy would be a second one. If the title is joint tenants, the surviving joint tenant typically becomes the owner by operation of law, and that's usually just with a recorded affidavit of death of joint tenant. Another would be community property with right of survivorship. It's a similar outcome as joint tenancy. The surviving spouse may take automatically with a proper recording. And then there are some small estate procedures in California that allows you to collect certain assets, but real property has certain special rules and limitations. There's also a court petition procedure for certain small real estate property sales, and that's going to be typically under probate code 13150 and 13151. And under that type of process, it's simpler than a full probate, but it still requires court paperwork and timing. If the decedent was married, they could file potentially a spousal property petition where that would allow them to confirm and transfer property, which can be much faster than a full probate. And then there would be the, in the world of real estate, relatively new transfer on death deeds. They've been around for, 10 years or so, which allows the owner of the property to properly execute and record a document allowing a beneficiary to take upon their death. But these can be contested, and they have strict compliance requirements. So, I always tell agents, don't decide the legal pathway for yourself. Just identify which pathway might apply and get the probate lawyer and title involved early, as always. So who has the authority to sell in this case, right? And when do they get that authority? In probate, the person with the authority is the court-appointed personal representative. And you'll hear three main terms. It's going to be the executor is the person named in a will and appointed by the court. The administrator is appointed by the court when there is no will or no executor is willing or able to serve. And the personal representative, or the PR, and that's an umbrella term for the executor or the administrator. But the real estate takeaway in all this is no one has the authority to sell probate real property until the court issues letters. And that's either going to be letters testamentary in the case of an executor, or letters of administration in the case of a person passing without a will. So the next thing you need to take a look at is, what is that authority? What authority does that person have? And it's going to be the difference between full authority and IAEA authority. IAEA stands for the Independent Administration of Estates Act. And if the PR has IAEA authority and it's granted by the court, then they can usually sell real property without court confirmation, but it's still subject to the required notices and other conditions. If they have full authority, then the sale of the real property typically would require court confirmation. That's a classic probate sale where you accept an offer, you prepare for a court hearing. The sale can be subject to overbids in court. And as an agent, one of the first questions that you need to ask is, has the PR been appointed yet? And do they have IAEA authority or full authority? So if you could take only one thing from here today, remember, if there are no letters, your PR has no authority. And that's where things start to break down. So what are the documents that title or escrow are going to be requesting in this case? They're going to be requesting certified letters testamentary or certified letters of administration, not just a photocopy. They're going to be looking for an order for probate, which would be, again, often be a certified copy appointing the PR, a certified death certificate, again, not a copy, identification of the personal representative, and sometimes a statement of information, certified copies of any court orders that affect the authority to sell. That would be especially, an order granting IAEA authority, if that's applicable, or an order confirming the sale if court confirmation is required. So, and then there would be notice-related proofs in some cases. That would be publication, mailed notice compliance, an affidavit of domicile, which is often requested for tax and reporting purposes, and escrow instructions signed by the personal representative in that representative capacity. If there are multiple heirs or beneficiaries with conflict, title might require additional court orders for clarity. So your escrow officer and title officer are underwriting risk. If they can't paper the PR's authority, the deal doesn't close, even if the family's all in agreement. You're not going to change the escrow and title's minds on that. That's their job. That's what they're going to be doing. So the timing of this, the probate timelines are not like a normal sale. And the biggest service you can provide your client is setting expectations early. So here are some early and typical time drivers. Appointment timing, getting the PR appointed can take time. There's going to be a filing, a court hearing day. The attorney is going to have to address any defects in the petition. There's going to be notice requirements. Probate's going to require various notices, publication, mailed notices to interested parties. There's going to be creditor issues where if there's a creditor claim process in probate, that doesn't always block a sale, but it can affect distribution and can create caution if debts or disputes are significant. The court calendar is obviously always an issue in the world of law. If court confirmation of the sale is required, you're at the mercy of the court calendar. Hearing dates can add weeks, if not months. I had one in Orange County that took, we're pushing a year and a half to get the thing through the process. And then the property condition and access. Often the property's vacant, there's deferred maintenance, or it has limited access due to family logistics, locks, tenants, that kind of thing. So when you're structuring a deal that involves any type of a probate, be really realistic, right, about longer escrow periods, the contingencies that are aligned to court events, and clear communications to buyers about whether there may be a court hearing or an overbid process. If you're on the buyer side, you want to know upfront whether this is an IAEA sale or a court confirmation sale, because the strategy and the timelines are going to be completely different. Again, IAEA sales look in large part just like any other sale. They're not having to go back to the court. They're not having to get permission. They're not having to get confirmation, any of that. So that's a huge thing for you to know right up front. So on your listing or agreement or any of your contracts, that type of thing, the disclosures, signature blocks are important. In a probate sale, the seller is the estate acting through the personal representative, right? So the signature block should reflect that capacity clearly. Basically would be name, Joe Smith as personal representative of the estate of the decedent's name, James Smith, deceased. Don't use heirs' names or beneficiaries' names as a seller unless the counsel and title confirm that they actually have the authority to do that and the deed pass supports that. You don't want to just have a beneficiary listed. They have absolutely no authority to do anything. In probate sales, you're often going to involve a personal representative who never lived in the property. So the practical disclosure reality of that is that they're going to have limited knowledge. There's going to be a lot of unknown responses where that's appropriate. And there's going to be a heavier reliance on inspections and third-party reports. So a few of the disclosure items that agents should be thinking about are the TDS, the transfer disclosure statement. Probate sales can have exemptions and modified disclosure practices depending on the transaction structure and who is selling. But the exemptions don't mean no disclosure risk. So, talk to escrow title and the probate attorney and use the correct forms and instructions. Secondly, there's going to be the NHD, the natural hazard disclosure. It's typically still required in practice, and buyers are going to expect it. If it's a pre-1978 property, the lead-based paint disclosures are typically going to apply. And then if there's been a death on the property, California has rules about the disclosure of death on the property within a certain time window and certain exceptions. Agents should treat this as a standard checklist item and coordinate with counsel if there's uncertainty on that. So in probate, I see agents who get into trouble not because they lied, but because they guessed. Right? Unknown is often the accurate answer when the personal representative didn't live there. So again, looking at those common pitfalls, red flags, and buyer side due diligence in a probate sale transaction. The red flags you should look at early are going to be if there's no letters yet, but the family wants a list immediately because we're all in agreement. If there's multiple heirs fighting or a sibling saying, I object. If there's unclear title, there's missing deeds, unrecorded transfers or vesting in an unexpected way. If there are tenants in possession, especially with unclear leases, rent control issues, or cash for key type dynamics involved. If there are lender HELOC issues, payoff demands, missing documentation, or a lender that won't speak to anyone yet. If you've got HOA problems, delinquent assessments, liens, lack of records. And then we've obviously got the issues now California has done it once again and made our life all a little more interesting. If there are property tax and Prop 19 issues at a high level, there's going to be reassessments and exclusions. They're planning sensitive, and families can be surprised after closing about what that means to their bottom line. So if you represent the buyer, the practical due diligence steps are going to be asked, has the personal representative been appointed, and do you have certified letters? Ask if the personal representative has IAEA authority, or will there be a court confirmation? Confirm who will sign the contract and the escrow instructions, and build timelines that reflect probate realities, especially if a court hearing is going to be required. Pay close attention to occupancy. Vacant versus tenant occupied can change everything. And don't assume that disclosures will be strong and robust. I mean, you need to plan your inspections accordingly. If you're the buyer's agent, your buyer's biggest risk is time and uncertainty. So your best tool is verifying the authority path in week 1, not week 3. So here's a quick practical checklist that you can use to keep probate sales smoother. Number 1, confirm the pathway early. I say this in every real estate transaction. It's especially true in the case of a probate sale. Whether there's a full probate, there's a small estate petition, spousal property petition, transfer on death deed, or a TOD deed you'll hear, or a non-probate transfer. Second is confirm authority. If a personal representative has been appointed, make sure they have certified letters in hand. Confirm the sale type. If it's IAEA authority versus full authority requiring court confirmation. 4 would be get title involved early, as always. Order a prelim early. Ask what they'll require from the court file. Draft correct signature blocks. Set realistic timelines. Court calendars and notice requirements really drive escrow length. Make sure that the disclosures and inspections are received, but understand that they're going to just expect it. There's going to be limited knowledge. Rely on inspections, the NHD, and when appropriate, those statutory disclosures. And then flag the tax issues at a high level. The Prop 19 and reassessment consequences matter, and refer that to a CPA or a state counsel. So, look, to wrap up, probate real estate can absolutely close smoothly, but it's authority-driven and calendar-driven. The earlier you confirm who has the power to sign and whether court confirmation is required, the fewer surprises you'll have. And again, this is educational, not legal or tax advice. I just thank you for your time, and I just wish you the best of luck in all of your endeavors.